Stephen A. Williams, president and founder of the creditrepairshop.com. In today's video, I'm going to deep dive into a topic that's dealing with debt, specifically debt collection letters. I had made a YouTube short that has actually taken off where I had stated why debt collection attorneys do not review the debt collection letter that is being sent out by their company, by their firm. So why don't debt collection attorneys often review those letters until they're ready to take people to court? And a lot of people were commenting on that video and they were like, well, why? That it doesn't make sense. Why would that ever happen? So in this video, what I'm going to do is I'm going to tell you why this happens. First, let's understand what a collection letter is. When you owe a debt, collection agencies are going to send these letters to remind you of your obligation and to try to push you for payment. Now, we all know that you have rights dealing with those, and I have other videos that go into more detail about what you can do when you receive a debt collection letter. But for the purposes of this video, so I can remain on topic, I'm going to go into the reasons why debt collection attorneys do not actually review debt collection letters until they're ready to take people to court. But here's the thing. Most debt collection attorneys don't actually look at these letters unless they're planning to escalate the situation to take people to court. And here's the reasons why. Reason number one is just total efficiency. Debt collection attorneys handle a large volume of cases. Reviewing every single letter would be time consuming and actually costly because debt collection attorneys actually bill their clients on an hourly basis. Now, if they're buying debt and trying to collect the debt, it still would add to their cost if they had to review every letter. What they do is they push that out reps to do all of that work. So they rely on collection agencies to handle the initial stages of the debt recovery, and this could be their own staff. So by not reviewing each letter, they save valuable time and resources, allowing them to focus on cases that are more likely to result in legal action, because we know that a number of the letters that go out for the amount that's owed, a lot of those don't actually end up going to court. Number two reason is just like a strategic decision making process. As attorneys access the likelihood of recovering the debt through litigation, they prioritize cases with a higher chance of success and a higher for the higher debt amounts. And we all know how that works. So even though in practice, what I've seen, at one time it was where they were just going after everybody regardless of the amount of the debt, because they knew it was going to be a high probability that it was going to be a default judgment, and they can move that over to doing a garnishment. What I've seen over a period of time is that they had changed it, and they only started to go after debts that were about $1,200 and higher. I've seen it come back full circle though, where they are starting to put some of those lower amount debt collection lawsuits together. And I have two suspicions on why this is happening. Number one, back to the old reason, is that most people won't fight it and it'll end up being a default judgment. Number two, with the advent of being able to get help and to be able to pay for services to fight those debt collection lawsuits, the amount that it would cost you to have the response written could actually be close to the lower amount, to the amount of the overall balance. So people could make a judgment call and say, well, maybe it might be better to just approach them and settle the case. So like, let me give you an example. Say they're suing you for $1,000 and it's going to cost you $500 to have a response prepared to be able to fight that case for $1,000. You might just think, well, what if I approach them and give them the $500 to make the case go away? That's their thought process also. So it's a matter of weighing the potential returns against the cost and efforts involved in pursuing the debt collection through the courts. And again, when they file those cases in the court, they also have to pay a fee to the court to file that case. So now, reason number 3 is a legal threshold. In many jurisdictions, there are specific thresholds for legal action. Attorneys wait until the debt reaches a certain amount or meets certain criteria before they get involved. So if, let's just say, for instance, debt collection is a lower amount, and you've seen this happen where it's like they're beefing up, letting fees and other stuff beef up before they actually take it to court, which could be a violation, but this is the way that they do it. Because if they're going to have a fee, let's just say that the case is, $1,000. They're not going to normally try to take that to court because they're going to pay usually for small claim about $150, $175 just to bring the case. So they're already into it for let's just say $1,175, and they want to kind of base the likelihood on them being able to get that case resolved and the likelihood of them being able to get the 175 back plus the majority of whatever the amount of, which would be that $1,000. So they're really, there's a lot of thought process that goes into this. And then another thing is they want to ensure the efforts and expenses of the litigation are justified. And every debt collection law firm has their own processes in place to see if this is going to work for them. It's different with all of them. So what does this mean for you if you're receiving debt collection letters? This means that as long as your case is at the letter stage, there's still time to negotiate and settle the debt before it potentially escalates to court. And again, this is your own decision. You have a right to fight it. You have a right to also say, I just want to settle this and just, be done with it. Listen to me, there is no right or wrong if you're just trying to just get this stuff over with. Some people don't want to have to go to court. So here's some communication tips that you can use when talking to debt collection agencies. Try to negotiate a payment plan if you can't afford to do a lump sum. You can seek advice from a financial counselor or an attorney if needed. Be careful on the cost, because if it's for a small amount, you may not need to consult an attorney because you're going to, the fees, they bill by the hour and you can end up paying more than what you're actually paying to settle the debt. And then understand that it's a process that it could take some steps to be able to get to the outcome that you want. Because, depending on what debt collection company that you're talking to, depending on the representative, because some of them can have attitudes. You've probably got some of the calls if you've heard, other people's experience when dealing with debt collection companies. It could be different with all of them. So what I would suggest is that you get your goals in place. If you don't want to end up going to court, then your number one goal that you got to have in mind, even if you get on the phone with a nasty debt collection representative, you have to just be prepared to push forward to get to a resolution. If you don't have the money for a lump sum, and remember, they're not going to always be willing to go low at first. But if you only have a limited amount of money, here are some things that you can consider that have worked for my clients, and it actually worked for me when I was going through my own debt issues back in the 1990s. Is that, number one, if you have the money to settle and you have an amount, I would say 50%, you're going to have a good chance of settling that debt. They're going to start high. You're going to have to go back and forth. When you're communicating with them and you're honestly communicating and negotiating, they should not move forward with trying to take you to court. If they do try to take you to court, you can let the judge know that you're in communications with them with settling and that you want to hold off the case. The judge will make that decision on that. And usually it will be held off. And even when especially when you're dealing with a lawyer, because like what I said earlier, they are in court, they have a whole bunch of cases, and trust me, lawyers do not like to take up their time. That's just built in them. So you have those options of trying to have that back and forth to where you can just push for more time to try to get them to come to that lower dollar amount. If you end up having to go to court, and this is from experience, if you end up having to go to court, you can tell the judge, I've made good faith offers based on my financial situation, and you can present that if it ends up going into court where you have a court hearing. Most of the time, though, the judge will just say, hey, can you go in a room and you can push for that 50% or even a lower amount? Have that back and forth with the plaintiff attorney, and you can get that amount lowered. You can do that. I've seen it done. I've even done it myself. And yes, they're going to try to start higher, but you can push to have them go lower. Next, if you don't have a lump sum amount, you can push for payments, and you can push for a payment that you can afford to do. Even if you might be coming into some money later, what you can do is you can say, hey, can we do a payment arrangement at an amount that I can afford, and then let's revisit it in 6 months. Or if there's a payment amount that they offer and you cannot afford it, you can say, can we do this for 6 months and then revisit it in 6 months to see if my situation changes. They will take those options. Trust me, we do this all the time at the Credit Repair Shop. So I wanted to clarify with this video. Please like this video, because when you like this video, you help other people get exposed to my channel to get help with their credit and debt. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early, this would be the excellent opportunity to send the letter, either my statute of limitations letter, cease and desist collection activities letter, or debt validation letter. Thank you for your time. Subscribe to the channel, and please watch another video or rewatch this video.